This is a case where the wife, both of them, my lord, go to Meghalaya for honeymoon. It's a predetermined murder. There are three accomplices, my lord, traveling along with the wife. The wife takes the husband to some hilly areas and kill. She participates in the assault also. That's the charge sheet. And the body is thrown in the valley. Body is found after, my lord, almost 10 days, my lord.
It was thrown or she was pushed into?
Yeah. No, he was killed, and thereafter the dead body was thrown into the gorge, my lord, which was found after 10 days. Thereafter,
who actually killed him?
the three assailants brought by the lady and the lady herself. She was also a part of assault, physical assault. Now, my lord, kindly show, my lord, allow me to show only, my lord, 3 pages.
Yes.
My lord, first page, my lord, I would request your lordship to see. My lord, she was arrested, she absconded. She was arrested somewhere in Uttar Pradesh. The offense is in Meghalaya. My lord, please see page 137, the order of transit remand, because we have to take her, my lord, 137, where the learned magistrate records that I am satisfied that the grounds of arrest are given to them. My lord, para 8. I have spoken to each accused. Does your lordship get?
Yes.
This is magistrate's order. I have spoken to each accused. They have each stated that they are aware of the reasons why they have been arrested. I have heard them verbally state the reasons and grounds of their arrest. So judge also tells them that these are the grounds.
Yes.
And I am satisfied that they are well aware of the reasons of grounds of their arrest. I have asked them whether they have engaged in counsel, etc. Not relevant. Now, my lord, they applied for the bail for the first time, rejected. They means I am the lady. I am not concerned with others. Please see page 161. My lord, and see, my lord, I am sorry, I generally don't do this, but my lord, see the name of the learned judge. Same judge. I am not, my lord, on the name. Same learned judge.
161. Yes.
161. This is rejection of second bail,
Yes.
where the learned judge says, having heard learned counsel for both sides and on perusal of the charge sheet and material on record, there is a prima facie material for believing that accused is involved in commission of the crime. Moreover, considering the conduct of the accused after commission of the offence, there is every likelihood that she will abscond. Hence, this court is not inclined to grant bail. They, my lord, again apply for bail, and your lordships would get, my lord, the third order of bail at page 168.
Yes.
But 169, my lord. Reasonable grounds for believing that there is no likelihood that she will try and influence the witnesses. No explanation has been offered by the petitioner for intervening period between the time she appeared after the murder of victim and her resurfacing in UP. Thus, suspicion weighs heavily on the petitioner. Hence, this court is not inclined. My lord, she again files a bail application. My lord, before that, my lord, I must say, a supplementary charge sheet is filed. Very interestingly, in the supplementary charge sheet, it is found that she was, as a plan B, carrying a gun also. That if the husband cannot be killed by assaulting him on the hills, he can be thereafter, my lord, killed by way of a weapon. Weapon was recovered and supplementary charge sheet was filed. My lord, thereafter she files fourth bail application. This is by the same learned judge, my lord. And please, my lord, have a look at page 205. My lord, the ground is that in the grounds of arrest given, instead of section 103 BNNS being mentioned, what is mentioned is 403. Lord, there is no 403 in BNSS. And the learned magistrate has explained her the grounds of arrest. That's, my lord, a matter of record, and I have read that order. Now, please see, my lord, page 205.
Yes.
My lord, by which the same learned judge, my lord, grants the bail, my lord, at 205.
Yes.
A bare perusal of the intimation of grounds of arrest would indicate that the petitioner was not informed about the offence under section 103(1) BNS. Though it has been argued that this is a clerical error, however, such error cannot occur in all documents. In fact, in all documents pertaining to so and so, from the checklist for justification of arrest.
All right.
So, but my lord, this is in the teeth of, my lord, the judgment of your lordships, my lord, where the law is settled. my lord, that is the judgment in state of Karnataka versus Darshan. And my lord, kindly see at page 203, which is quoted, my lord. 203, the judgment is quoted.
Yes.
20.1.5. This is the judgment of this honorable court. While section 50 CRPC is mandatory, the consistent judicial approach has been to adopt prejudice-oriented test. Well, this was also, bail was cancelled. The ground of bail was, the grounds were not communicated. And the court says that we will have to show prejudice. Prejudice-oriented test.
Just leave the judgment and then go over it.
Pardon?
There are two views about it. There are two views on this judgment. Therefore, you can leave this and go to the next issue.
Yeah, yes. My lord, ultimately, my lord, she was informed about the ground of arrest. Only typographical error 103 becomes 403. Thereafter, my lord, for 3 consecutive bail applications, she doesn't raise this ground. She was produced before the magistrate. She was being she was having the legal services. She was represented by a lawyer. No ground taken. She says that I could not take that ground, but it's a legal ground. Please have a look at, my lord, that application. She admits that I never raised this ground. And 103 and 403, my lord, this is the only ground where, my lord, the view, my lord, apart from this judgment, there are other judgments that you don't release somebody on technical grounds.
That's correct. Now, what is the stage now? How long
The
she is in
stage
there?
is that of trial, my lord, but the learned High Court confirms this. It's really painful.
How many witnesses have been
The
examined?
witnesses are being examined, but they are all her employees.
Well, it's only 4 out of 90 witnesses.
Her employees.
Well, it's 4 witnesses out of 90 witnesses.
There are 9.
See, counsel now will hear you, no problem.
There are 94 witnesses, and this sets a wrong precedent.
Prima facie, we have our own reservation about the High Court. What we will do is we'll stay. You file your response. We'll see how fast the trial proceeds.
So that will cooperate.
See,
It can even be day to day.
Well, I've been cooperating with the trial.
Please do that.
Well,
But at least let's see how far. Let us reach a stage, then we'll consider it, because we don't want to pass an order today. So let things go on, then we'll see. Then at least
Your office may stay the order.
that's right. At the time,
Yes, sir.
we let things go on.
Well,
We'll take it up. Prima facie, we have our own reservation about the way in which the High Court. See now, when earlier leave alone all the legal issues. That's why we said that all the other issues raised. The fact remains that you have been informed, number one, about the grounds, and the facts have been told to you.
Magistrate informs it.
We'll hear you. We'll tell you. One. Number two, in the earlier bail applications, you have not raised this issue.
yes.
Number two. See, the third one is that it is not a case where the grounds of detentions have not been served. If it is not served, whether the judgment of this court will be prospective or retrospective, prejudice to be shown is one aspect of the matter. So, prima facie, my personal view is that if the law says something, it has to be followed. No difficulty on this. No difficulty on this. So, but the fact remains, the facts are different here. In this case, grounds of detentions have been issued. Then you answer it, there's an issue. And you did not raise anything. Then you write the regular bail application. But thereafter, you see somehow wisdom dawned on you, then thereafter you raise this issue. And when on the earlier occasion, the court have gone into the merits and that said, all right, we are not inclined. Is the courts are right in rejecting it only on the technical plea, especially with respect to the quoting of probation. Quoting of probation is not a big thing. There, I think prima facie is right because prejudice will not be shown. And the wrong quoting the provision
does not exist.
That's not the case. That's not the case.
Now, please.
There is no. The only issue is not with respect to the typographical error, as has been pointed out. No grounds of arrest were communicated to the respondent at any point of time. Now, she was initially arrested on 9th of June.
I have communicated.
She was arrested on 9th of June 2025, which was the transit order. Your Lordship would see, nothing record. She was not even represented.
See,
now,
you're right. See, in that case, what the court should have done is, it has not been served on her. Then it's a different footing. Now, Then the only issue is whether it is served or not.
It is served, there is no dispute.
And the incidental issue will be, if so served, at what time you can raise this plea?
Now, your lordship would see, if I may,
the most important aspect
if I may,
is
if I may show, if I may show,
that these are the grounds of
if I may show, what has been, what has been said today. He says, grounds of arrest have been communicated to the respondent. If your lordship would see, it's a performa that has been served. It does not contains anything. Now,
See, that's why.
question here is,
Therefore, you are right. If that is the case, if you agree with that, then the other question the question framed by us will not be available, right? Then the next question will be whether it constitute a proper grounds of detention. It satisfies the grounds of detention.
Yes.
That's only.
that's the question here.
Then the next question will be whether that plea can be permitted to be raised by you after the regular bail is filed on couple of.
I'll tell your lordship why.
No, wait. And then because all those things, we are trying to we are raising another issue with you for you to consider. Now, if the trial court and the high court have considered this issue only, consider the bail only on this footing, would the law debar them from arresting you tomorrow? Think over. Would the law debar you from arresting you tomorrow? Because they did not give any bail on any other ground. Let us assume today they give you another grounds of reduction as you wish it to be. Would the law debar them from arresting you tomorrow? That is why we said you just think of we'll state for time being you file your response. We will see how far trial proceed and. And then presumption can be invoked to a certain extent. That though the gravity of the offence is also a factor to be considered, we will consider it because if you want us to consider, we'll consider today because we understood the case pretty well. It's not difficult for us. So you file your response and then we'll see how far it moves and then we are trying to think of having a balanced approach at the appropriate time.
My only request is, Lordship, since I have been put to strict conditions, I am already in Shillong, the question of absconding or tampering with the evidence does not arise because charge sheet has already been filed, whatever was seized has already been seized.
No, that cannot be.
It is not their case that there's some recovery to be made from me. I am on something else. I am on something else.
You are right.
So, today, if your Lordship tends to stay this order, it in effect cancels my bail, If your Lordship
not the cancels, it's putting it on hold.
Yes.
We are saying we are considering your request.
I may not be taken into custody. In that case, I am already in Shillong. I'll file my response to that effect.
No, we don't think so. We don't think so. We like to satisfy the matter of this nature concerning the allegation. Some progress is made at the trial. Otherwise, we'll pass an order today. Otherwise, we have no difficulty in passing an order today. We are trying to put it to you. Hopefully, you have to appreciate.
I'm so grateful, for that. And my only submission today is, since the charge sheet, I understand, the nature, gravity of offence, etc. Lordship would appreciate, I've already been in custody for some time. Now, charge sheet has been filed. I am already put to condition. I am in Shillong. I am not even in Indore or some other place.
Be there in Shillong, no problem.
You were in Shillong and you not flee to UP. You were arrested from UP. This has to be
now she's in
Shillong. I've been put to condition by learned trial court that I cannot leave.
Are you in Shillong now?
I am in Shillong,
This is no argument, for.
No, she's released now.
Yes.
She is released,
Then it's released, then we can't say.
The lordships can.
But then if she's released, then we don't want to do it.
It's been 3 months, I've been
ground.
cooperating. I've been cooperating in all this, sir.
Lord, on this ground, the same judge, my lord, who deals with 3 applications, on the 4th one says that instead of.
All right. She's released. We thought that she's not been released.
My lord, I have not given your lordship, my lord, the facts which would shake your lordship's conscience.
It is true.
He is found, my lord, coming back from the killing with one of the assailants on the motorcycle.
We appreciate, we understand. But then there's a matter to be decided in the trial. See, we are also conscious of the law laid down by this court that there are certain parameters to be satisfied when bail is granted. Now that's correct. But now, when she is released, we don't want to pass an order now, asking it to
Not
put
the
it back.
difficulty, I
We
think,
initially, we gave permission to you on the premise that she is not released, she is
Lord,
inside.
I didn't want to say this.
Yes.
Immediately after the order was passed by the learned, my lord, by the special court, my learned friend, the Advocate General, my lord, mentioned before the roster bench,
Yes.
my lord, it was not taken up.
So
Otherwise, we were seeking stay of that.
No, we appreciate that.
The order which
but
impugns.
see, you mentioned yesterday we gave it, but honestly, on the premise only we gave the permission. Then probably we will
But
not.
now,
You let them file your
my
response.
lord,
I'll
ultimately,
file the response.
only a minute, ultimately, your lordships may not pass an ex parte order. They are here.
Yes.
Your lordships would not have passed an ex parte order. But now they are here, my lord.
So we taking the cue from your argument. Suppose if we are not here, what is the order you expect us from the past?
Possibly your lordships would have issued notice, but fortunately,
Then
he is here.
that cannot be put against the council.
No, not
Okay.
council, my lord. The
No,
litigant has
let
chosen to be here.
Let it be.
My lord, kindly see the
No,
seriousness
we
of the
appreciate, we
offence.
appreciate that, but we don't want to see now.
My lord, kindly have it next week.
No, we'll give short date, no problem.
No, my lord, next week, my lord. Let them,
We'll take a chance.
they can't have the luxury, my lord.
All right.
Mills, it's not luxury, Mills. I
Then
believe
the SG appealing for the petitioner submits that both the courts have not considered the relevant materials, including the recording made by the court on the earlier occasions. It's a case, apart from the nature of allegations, which are quite serious, the fact that the earlier bail applications have been rejected and the present plea has not been raised, have not been considered. A further submission has been made that it is a case of, not a case of the grounds of detention not served, but not, not containing the adequate reasons. This has to be
No, my lord,
seen.
only typographical error in one section.
And along, apart from typical reason,
And the
reliance has been
can
made.
record magistrate has informed
Reliance has
other
been
grounds.
made on the order passed by the learned magistrate in the presence of the respondent. Next paragraph. Learned counsel appealing for the respondent seeks time to file counter affidavit. It is also submitted by him that the order granting bail has been given effect to. So that's what, considering the submission made, we are not inclined to pass an order of stay, particularly when.
My lord, the lordships may not say that,
All
because
right.
I may press for
All
the
right.
interim order after he files a reply, my lord.
Considering
And I
the
will
above,
press for this.
taking note of the above, we are inclined to post the matter for further hearing on the next Thursday, next Thursday.
Any earliest possible.
Mills,
Next Thursday. Next
Lord,
Thursday.
next Thursday.
Lord, these instances are increasing. The lordships must be reading in newspapers.
Mills,
See, you see one of our judgments where we have dealt with a case a similar case, a very sensational case from Bangalore. We don't want to say anything further. If I say something, it will be highlighted again.
Yes.
I think now there's an element of interest